Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. We got some fairly recent news in the bankruptcy world as the United States Supreme Court has handed down its decision in the Coughlin case, confirming that Native American tribes are indeed subject to federal bankruptcy laws, in particular the automatic stay against efforts at collecting debt. So this case began as a typical bankruptcy case in Massachusetts that found its way all the way to the United States Supreme Court. So before we get into the case, let me give you a little bit of background. If you haven't come across a tribal loan business before, this is more or less how it works. Native American tribal government will associate with or own a financial lending service. And because the lender is considered an arm of the tribe, it can take advantage of the tribe's sovereign immunity in relation to the regulation of consumer lending transactions. So while individual American states each have a limit in the amount of interest that a lender can charge, those regulations don't reach these lenders because technically they're on tribal land. So the result is that many of the online payday loan lenders that you see out there, they're affiliated with a Native American tribe, and many of them charge very high interest rates on their short-term loans. Of course, as allowed by the individual tribal bands that they associate with. So some of these short-term loans have interest rates between 25 and 100% interest, but many are much, much higher. And in fact, there was a report that I read that one lender was charging up to 950% interest. To me, that sounds worse than dealing with the mob. But if you value your kneecaps, maybe you'll put up with 950% interest if you're feeling or if you are really truly that desperate. But anyway, online payday lending is a big business. It makes tens of billions of dollars each year from people who are in a bind, living paycheck to paycheck, and usually just need a few $100s to get by until the next paycheck. So Mr. Coughlin was just such a person. Coughlin took out an $1,100 payday loan from a place called Lend Green. It's a wholly owned subsidiary of a tribal band. And a few months later, Coughlin filed bankruptcy. As you may know, in most cases, the filing of a bankruptcy stays all efforts at debt collection. And the problem here is that, as Coughlin and many others have found out, is that a lot of these places, these online payday loan lenders, couldn't care less about the automatic stay because they think it doesn't apply to them. Despite the automatic stay, the lender continued to contact Coughlin in this case and demand payment, and about 2 months after he filed bankruptcy, Coughlin attempted suicide. He said that his mental and financial agony would never end and that he was pushed to the brink by Lend Green continuing to call and email him about this debt that he owed after he filed bankruptcy. So to enforce the automatic stay, Coughlin's attorneys filed motions in the bankruptcy court to find the lender in violation of the automatic stay. In response, the lender filed a motion to dismiss, claiming that they were shielded in their actions by tribal sovereign immunity. The bankruptcy judge held that bankruptcy law did not abrogate the sovereign immunity. So meaning that the law that has developed over time basically says that Congress does in fact have the power to abrogate tribal sovereignty, but when it does so, it must be clear and unequivocal. And the bankruptcy judge in this case ruled that the bankruptcy code was not clear about the automatic stay applying to tribal governments in particular. So he dismissed the case for lack of subject matter jurisdiction, or dismissed the motion for sanctions. So Coughlin then appealed the decision to the First Circuit Court of Appeals. And that circuit handles all federal appeals for most of the Northeast states, Rhode Island, Massachusetts, New Hampshire, I think another one, but strangely enough, Puerto Rico is also a part of the First Circuit. But the First Circuit reversed the bankruptcy judge's decision and said, yes, the bankruptcy code does include a broad abrogation of sovereign immunity that includes states, cities, and other foreign or domestic governments. And the First Circuit ruled that, yes, tribal bands are domestic governments for that purpose and are subject to bankruptcy laws as written by Congress. And finally, the United States Supreme Court steps in to finally resolve this matter and agreed with the Circuit Court that the bankruptcy code unequivocally abrogates the sovereign immunity of the tribe. So of the 9 members of the Supreme Court, it was an 8-1 decision. The sole member of the court to disagree was Justice Gorsuch. The majority opinion was delivered by the newest member of the court, Justice Jackson, and she held that the Bankruptcy Code's definition of a governmental unit that covers all foreign and domestic governments adequately included Native American tribes without mentioning them expressly by name. So I'm going to read a few passages from both the decision of the Supreme Court and the dissent that was written by Justice Gorsuch that I found interesting. So this case turned, as a lot of Supreme Court cases do, on really grammar in the English language and how it's constructed. I mean, that's really what a lot of these cases boil down to when they're trying to pick apart definitions. And the definition in this case that they looked at was how the Bankruptcy Code defines a governmental unit. That's found at Section 101, paragraph 27. And I'm not going to get into it's a lengthy definition, but at the very end of how it describes a governmental unit, it says, or other, it could include, or other foreign or domestic government. So the question for the court was, is a tribe on tribal land with sovereign immunity a other domestic or a foreign government? So they looked at the definition, the legislative history, and the Senate House reports that accompanied the code when that definition was written, and found that it was intended to be defined in the broadest sense possible. And this is, of course, Justin Jackson's opinion. And she writes, the petitioners claim the most natural and obvious way to have expressed that intent would have been to reference Indian tribes specifically rather than smuggle them into a broadly worded catch-all phrase. But Justice Jackson tells us that there's no magic words requirement. And the tribes they do possess common law immunity from suit traditionally enjoyed by sovereign powers. But because of that all-inclusive language, the court held that the Bankruptcy Code unequivocally abrogates the sovereign immunity of any and every government that possesses the power to assert such immunity. Justice Thomas, interestingly, did a concurrence. He agreed with the decision of the court, but for an entirely different reason. And his reasoning in the concurring opinion that he wrote is that immunity does not extend to suits arising out of a tribe's commercial activities conducted beyond its territory. Because respondents' stay enforcement motion arose from petitioners' off-reservation commercial conduct, petitioners lack sovereign immunity regardless of the Bankruptcy Code's abrogation provision. So Justice Thomas basically believes that this was the idea that Indian tribes enjoy this sovereign immunity is a judicially created rather than something in the law that's in the Constitution or in statute. It's been something that's developed over time through precedent through the Supreme Court, and he's urging the court in his concurrence to abandon this. And he does say when a tribe engages in off-reservation commercial activity, it necessarily acts within the territory of a sovereign state. So suggesting that because the tribe is reaching outside of the reservation to do these transactions, that they should just be governed by the state where they are performing these transactions. Justice Gorsuch wrote a very lengthy dissenting opinion that was interesting. Some of the points that he made is that tribes do enjoy a unique status in our law, and Indian tribes occupy that unique status that is neither politically foreign nor domestic. Neither the term foreign government nor the term domestic government adequately captures the tribe's unique legal and political status. And what he said was that the best the respondent could realistically hope for in this case is that they declared the definition of a governmental unit as a jump ball. And under our clear statement rule, a jump ball is as good as a possession arrow favoring the party opposing abrogation of sovereign immunity. So he believed that the tribe should have won in this case. And he goes on to say, further, the reader must treat the words foreign or domestic as a single undifferentiated clause rather than a disjunctive grouping of descriptors. Second, the reader must take that undifferentiated clause to mean anywhere and everywhere. A perfectly natural reading then would ask whether tribes clearly qualify as foreign governments or as domestic governments. And because the answer is no on both scores, for the reasons already laid out above, the language flunks the clear statement rule. So Justice Gorsuch went on to say, when Congress includes so many items within an associated group, we assume the omission of another means that it was deliberately excluded. And this is an interesting concept because in a lot of ways that the Supreme Court looks at these grammatical rules is that the inclusion of a long list would suggest an exclusion of anything not listed. And so it is interesting to suggest that this definition is very long, doesn't include Indian tribes by name, or in clear reference to Indian tribes or tribal sovereign immunity. And Justice Gorsuch is basically saying that then it should be excluded. So Indian tribes occupy a unique status that is neither politically foreign nor domestic, going back to that again, suggesting that they can't be under that broadest sense term foreign or domestic because they're neither. They're unique. They enjoy a unique status in the United States as independent sovereigns. So that's it for today. I know it was kind of lengthy, but hopefully that is helpful, and this leads to a lot of relief for people who are being harassed by these lenders that associate with tribes that think that they're outside of the reach of bankruptcy law. For any other information, obviously contact my office with any questions, but subscribe to the channel, and thanks for watching.